sharing your thoughts. Um, Perhaps I should quickly introduce all the speakers before I begin to call them. My earlier impression is that Prof is just the chair, but it is nice to also have the chair's thoughts as we've had now. So to my left, we have James Bremen. James Bremen is a partner and in charge of the construction practice at Queen Emmanuel Sullivan in the UK. James is well known on the construction practice circuit. I'll be calling on him very shortly. Kash Balogun is a partner at Keystone Law, also in the UK. Um, like I said earlier on, I've known Kash quite a bit now. Kash is a very sound construction lawyer. Um, Smiling quietly at me is Matthew. Um, Matthew is a partner at K&L Gates. He's also a foremost expert on construction law practice. Abdul Jinodu, barrister at Keaton Chambers. I've known Abdul too for a very long time. I'll leave Abdul to reel out his intimidating profile in a short while. And then we have Professor Olajide Olagunju, adjunct professor. Um, Prof, I understand you have written a book on this area. Is that right? You're on mute.
Yes, I write some conflict resolution.
Ah, okay. So, let me quickly go to James. James will be talking about dispute boards. Is that right, James?
I certainly hope so, yes.
Good. So you have 10 minutes. Please proceed.
Thank you very much. And I'm going to time myself to make sure I stick to that. Thank you all very much for dialing in. I've got, as was pointed out, 10 minutes. And in that 10 minutes, I've been asked to address 6 questions. I'm going to try and do that as best I can. I was thinking about decided that slides would hamper me in the time available. So I'm going to do it orally. If you have any questions, please do put them in the chat. Before I start, I do lots of 10-minute talks. I'm used to this time period. And if you were interested in general sort of construction issues, on my LinkedIn page, I think I've got about 95 10-minute talks that you can look at. I did that last year. I had a lot of time on my hands. I suspect many people did. And so I did do 10-minute vignettes on about 95 different construction topics, English law as well as international. But today is dispute resolution boards, or dispute adjudication boards, as they're sometimes called. And I want to talk generally and to say, of course, many of you will be familiar with the FIDIC approach to these matters as set out in across the 1999 suite of the FIDIC contracts at clause 20.4 in particular. Which sort of clause 20 deals with the referral to a dispute adjudication board in circumstances where there's a dispute about an engineer's decision, and that is a well-known process. I don't propose to deal with FIDIC here, although I might make some reference to it, and that's simply because it isn't a FIDIC talk, but and dispute adjudication provisions can be found in any sort of contract. Who can refer disputes? This is my first question. Who can refer disputes and the procedures to be followed? Well, the first place that you look is the contract. A dispute adjudication board or a dispute resolution board will have its procedures set out in contract. It's not a creature of law. It's not a creature that exists by way of treaty, like arbitration under the New York Convention. It doesn't have that benefit. It's a contractual agreement. And so the first place that you start is, what does your contract say about how this works? Usually, and of course, if you look back at the FIDIC suite, it's a referral by the contractor in relation to a dispute about a decision by, in that case, the engineer. But in your contract, it might be the owner or employer's representative. But it's also the case that dispute adjudication boards in many contracts can go both ways. So, for example, the owner makes a reference to say, well, I'm claiming force majeure. The contractor doesn't like that. And they may also have a right to utilise the dispute adjudication board or the dispute resolution board process as set out in the contract. So you need to look at at that. And how does it work? Well, it works in lots of different ways, as I've alluded to. The dispute clause itself will look at how the DAB, the board, deals with the dispute itself. It normally allows the dispute adjudication board, whether it's 1 or 3 people, it can be both or indeed more, but there are the most common 2 formulations. They have very wide discretion as to how to conduct the process. Now, some of these I've done. I did one last year in front of a silk in London, and it was a single person. But it's also often the case that there are 3 people. And in that particular case, there were oral hearings, 2-phase oral hearings in front of him, written submissions. It was very much like a mini arbitration. But other DABs, including some that I've sat on, are just by the papers. The people submit submissions and the DAB conducts an inquisitorial process of looking at whether or not they're going to issue a decision on the issues in the time available, because sometimes the contract can say, for example, 84 days is the drop dead date. Otherwise, other times it's more open. And they make their own elections. Things to think about when you're reading the DAB clause: 2 things. The first thing is the dispute adjudication board making a decision which is contractually final and binding or not. There are 2 options here. Either it's effectively, well, there are 3 really. It's final and binding with no recourse otherwise, in which case it's a contractual decision. I'll come to that in a moment. 2, it's a process which is binding, what we call pro tem for now, and either party has the opportunity to refer that dispute to the formal dispute resolution process under the contract if they don't like it, and they can hear that from the beginning. The DAB decision doesn't mean anything in those circumstances, unless a period of time elapses and they don't make such an appeal or take such a step, in which case it becomes final. And finally, in circumstances where there isn't that period of transition between being able to appeal and not. So it's either binding or not binding, effectively. If it's not binding and you then need to go to arbitration, what can you do? Well, it's evidence, and that evidence can be put forward in the arbitration and will be quite persuasive. There's no reason that the decision of the dispute adjudication board would not be admitted unless you expressly agreed that it wouldn't. And the second thing to think about when looking at the clause is it a condition precedent to going to arbitration? Must you go through this process first, even if it's not binding? And some employers think that that's a very good thing because it makes the whole dispute process takes longer. And of course, it's usually the poor contractor who's out of pocket, not the employer. And again, this depends very much on the drafting. My next question is standing dispute boards or ad hoc boards, which are better. A standing board is effectively you have a board appointed at the beginning of the life of your contract, or usually some way into it, but not that far in, who brief themselves on the project and are available to resolve disputes during the tenure of the contract. It's very, very expensive. These people are put on a retainer, they need to read in, they're available as and when needed, and they need to stay abreast of developments. And so in those sorts of things, a standing board really is only used in mega projects. So I've done one on an airport, for example, where it was a 10-year construction period. That makes sense, having people there to do that. But on a smaller project, a project that has either a short time frame in terms of the time of the construction period, or a small value, that standing boards to me don't make a lot of sense. Ad hoc boards, which are called up as they're needed, they're not standing, are used also and are cheaper. But of course, an ad hoc board needs time to read into the project as well. You need to factor that in. Next question, why is it better at preventing disputes? They can short circuit disputes. They can get to the question and resolve things, certainly on an interim basis, pretty quickly. The issues about an effective DAB really are that they can resolve things quickly, but that only works if you have a very strong DAB and very experienced people sitting on it. You need people that if they make a decision and it goes before an arbitration tribunal, that decision will be given great weight by the tribunal because of who the people are and how they've approached it and the rigor with which they've done their job. And secondly, people with lots of experience know what the issues are and can pick out really what's between you, because unfortunately most construction disputes are basically the same, just involving different technology engineering. So you can usually pretty quickly spot it, and you can usually move quite quickly. Good people, a strong decision. Weak DAB members, not really first-class people. I actually think the whole system, certainly if it's not binding, really doesn't have much benefit to you. It does have a lot of benefit if you have very first-class people. Why would you do this? What are the benefits? Well, the benefits are an average construction arbitration can take 2 to 3 years. I'm on one at the moment that's in year 8 at the moment. Construction arbitrations can run for a very long time. They can be horrendously expensive. Parties' positions become entrenched. It becomes very difficult to get to a resolution. A DAB provides an ongoing basis of trying to short circuit that, retain relationships, particularly if it's mid-construction, and avoid large disputes at the end. But you do need strong people. You also need to think about the issues that are going to be in dispute. And one area I do have some concern about DABs is delay claims, and that's because of the need to have strong technical evidence and strong programming support on them, and the time available to execute that within the DAB process in a short period of time that's needed. But you can manage that, but you do need then to add to the DAB effectively a full-time programming person, which I've seen done, but again, increase the cost. Enforcement of the decisions. Well, the decisions themselves, as I've said, are not made under a particular treaty. They are contractual. And so just like decisions under the contract, you need to go to the dispute resolution provisions and seek to enforce it either by way of arbitration and then following that, if you succeed, the New York Convention, or if there's litigation, to the local courts. And so there is, some issues around that. There's some English case law about whether FIDIC requires you to take the disputed DAB decision back to another DAB as a function of the way one of the oddities of Clause 20 in the 1999 FIDIC suite. But I think that's, whilst there is a decision, I think it's a bad view. And I think the better view is that if you have a DAB decision, you look at 20.4, you can probably just run off straight to arbitration if the other party is not honouring it. In terms of the final analysis, it's very good for big projects. It's costly for small projects. My personal tips: have the best people you can possibly have sitting on your DAB if you're going to have it. It won't be cheap. Standing is the best, frankly. So a standing DAB is best in my opinion. I also think you ought to give serious thought as to whether to make the decisions binding, because otherwise, if one party doesn't like it, you really just wasted time and you end up in arbitration anyway, or at least binding pro tem for that interim period with the party given the opportunity to appeal. And you do that because then it's not a lot different to adjudication. It's effectively contractual adjudication. And at that point, cash flow, which is important to a contractor, is kept. So the decision is made to pay money, that money is paid. The DAB process, if it's standing with good people, with the right support, a referral to DAB won't necessarily be the total war that a referral or notice to arbitration would be, because it will be seen as part of the process, hence keeping the relationship strong for the period of the project. And those things are all very good. But on smaller projects, it's probably not. My time is up. Thank you very much.
Thank you very much, James, for packing so much within just about 10 minutes. Much grateful. One of the points that you mentioned is quite significant. That's the very first point. That's what does your contract say? Because that actually is a starting point of dispute resolution in the construction sector. The starting point, even if I may dare say, even the ending point always is what does your contract say? And most people always lose sight of this significant point of detail. But just a quick question to you, relating to enforcement. If to enforce the decision of a DB, you need to go to arbitration, and then probably get a binding award, which you need to go back to the courts to go and enforce. Is that not a very long-winded process? Why not just get a performance bond so that once the DB gives a decision, you can just cash in? What do you think of that?
I'm getting some echo. Hopefully you can hear me. In the UK, there used to be something called, and indeed there still is, an adjudication bond, and that is performance security, which sets to provide assistance in similar cases. You may not have a bond which is big enough to cover the matter referred to the DAB. And also, if you do that, you inherently make the DAB process itself final and binding. If you're going to have a bond there sitting as security, in which case you don't need to do that. You could do that. It would be an additional cost because the purpose of that security is different to performance security generally for the balance of the project. Secondly, contractors may like it, they may not like it. Owners probably won't like it. The reason that we have DABs is effectively it's contractual adjudication, and in some respects, unless you have an excellent panel, it's quick and dirty. And so for smaller amounts of money, up to a certain value, I actually think you have a point. If we set a DAB decision up to X million dollars, we might consider being supported by a bond. I'm fine with that. But a DAB decision related to 300 days extension of time and $100 million, I'd have more sympathy with an owner saying, I'm just not going to carry that on an 84-day process. Thank you very much. I want my right, if I don't like that, to go to court or to arbitration. Addressing the second point very, very quickly, when you go to arbitration with a DAB decision, it might be that arguments are run about whether or not that decision is valid, and they might do that, and they can do that. But they, in theory, shouldn't look at the merits of rehearing what the DAB decision was about. All you're seeking to do is enforce that decision. And so the arbitration process should be relatively short. It should almost be like a hearing to enforce a settlement agreement. Is the agreement itself valid, not what the agreement's about? And of course, if the DAB decision is valid, then you'll get an award relatively quickly. Probably, unfortunately, the way, if it's ICC, you might be looking at 6 months from beginning to end, maybe even a little bit longer, maybe 8 months, but beginning to end of the proceeding and the award. And then you can enforce, and that will take longer. But for large cases, that might be worth considering. But those were both excellent points, and thank you for raising them.
Thank you very much, James. Grateful. So, Kash, I hope you're good to go.
Yes, I am.
So, Kash will be speaking on adjudication. The floor is all yours.
Thank you, Kola, and good to see you in person as well. We've sent loads of emails, but never actually met, so good to see you. And good afternoon, everyone. Thank you for dialing in. In the limited time available to me, I'm going to try to provide you with a bit of an introduction to adjudications and provide some brief discussion points on the slip rule and how compatible adjudications are with insolvency. As you know, disputes incur unwanted costs and delays in construction projects, as James has eloquently explained, which can be due to the fact that, it can take quite a while to get to a decision on the dispute, and also the fact that parties appeal these decisions. In the context of construction litigation, there's also the risk of the contractor becoming insolvent as a result of the prolonged, stagnation of cash flow while the dispute is being resolved. This is why parties usually try to engage in some form of alternative dispute resolution that will resolve the dispute quickly and allow the cash to flow. These range from parties negotiating between themselves to early neutral evaluations at one end and arbitrations at the other end. Now, adjudications lie between early neutral evaluations, which deliver private non-binding opinion on the merits of the dispute from an independent expert source. While arbitrations on the other side, also provide you with a private determination, or one that is binding and subject to very limited scope for appeal. Adjudications are similar to the early neutral evaluations because you get a decision from an independent source and you get it very quickly. In some cases, it can be within a month or so. But adjudication decisions are provisionally binding. So they're only binding until the matter in dispute is later resolved by arbitration or litigation, or even by agreement. Now, adjudications, are usually seen as a rough and ready form of dispute resolution, a quick and dirty. It all has the pay now and argue later, principle behind it. Now, adjudications have taken off in the UK and a number of other jurisdictions such as Ireland, Singapore, and Australia, particularly because it has been legislated on in these jurisdictions. For instance, the UK has encoded adjudications into its statutes, which has given parties the right and option to refer disputes to adjudication, whether or not their contract provides for it. In the UK, there's also a well-established summary judgment enforcement procedure that provides a swift resolution to the enforcement of an adjudicator's decision. In other jurisdictions, though, such as in Nigeria, where adjudications have not been enshrined in legislation, there has been less take-up of adjudications, despite the fact that the standard form contracts that are typically used in construction projects there allow for contractual adjudications to take place. That being said, there are other issues that do have an effect on the take-up of adjudications, even in jurisdictions where statutory adjudications are available. One such issue is the use of the slip rule. Now, due to the speed at which adjudications take place and the limited time available for adjudicators to provide their decisions, it's almost sometimes inevitable that errors do crop up in the decisions. But the question is, how can these errors be corrected, since the decisions are provisionally binding and can result in a party having to pay out significant sums? In most common law jurisdictions, the slip rule has been developed by case law, which provides that although an adjudicator may not revisit their decision on the merits of the dispute, patent and genuine mistakes or accidental clerical errors, for example, typographical errors or mathematical errors, can be corrected within a reasonable time. Again, in the UK, in some jurisdictions, the slip rule has also been introduced by statute. In the UK, the Construction Act was amended in 2011 to enable adjudicators to correct slips in their awards. The amendment required construction contracts to include a provision in writing that permits an adjudicator to correct his or her decision to remove a clerical error, whether it's made by accident or by omission. We also have a statutory adjudication scheme that was also amended to ensure that any corrections that are made under the slip rule have to be done very quickly. So within 5 days of the date when the decision is notified to the parties. Some adjudication rules as well, such as the ICE adjudication procedure, also allow the adjudicator to correct a decision to remove any clerical mistake, error, but it has to be done within 14 days of the decision being notified to the parties. So again, it all has to be done very quickly. Now, some important points to note about the slip rule is that, one, the adjudicator cannot amend the decision to give effect to any second thoughts that he might be having, because the decision has already been reached and cannot be changed. Just, patent errors, the smaller things. Then the timeframes for parties to point out errors to the adjudicator are also very tight, and amending an award out of time could cause the decision, the adjudicator's decision, to be rendered invalid. And thirdly, even if the contract does not expressly give the adjudicator the power to correct his or her award, common law may still imply such a term into the contract. Also, some of the issues that arise when adjudication decisions have been amended on the basis of the slip rule include issues about whether applying the correction under the slip rule is an election, i.e., by doing so, are you electing to be bound by the decision and preventing yourself from raising any challenges on enforcement? Issues about whether the correction amends the adjudicator's original intention or reasoning, rather than simply correcting a clerical mistake. Issues about whether consequential corrections are covered up under the slip rule. So, if due to a mathematical error, the referring party is awarded a significant sum, but once that error is done, it means, the responding party actually is the one that should be awarded a sum. Should that be covered by the slip rule? This was an issue that the UK courts recently grappled with, and they found that as long as the correction does not amend the reasoning behind the adjudicator's decision, then it should be allowed. I'm now going to try and move on to insolvency, an issue that we're unfortunately going to have to grapple a bit more with as more companies are likely to become insolvent due to the current pandemic that we find ourselves in. And the issue is really about, the compatibility between adjudication and insolvency. Bearing in mind that adjudication decisions are only binding until the dispute is finally determined by arbitration or litigation. There'll be situations that arise where a party might be required to pay significant sums of money to an insolvent company based on an adjudicator's decision, which could possibly be overturned by the arbitral tribunal or a judge if it's litigated. In the meantime, the insolvent company might be dissolved or might have handed over the money to pay off its creditors. Now, courts and lawyers will have to deal with these issues of what do you do if an insolvent company refers a dispute to adjudication? Do you engage in the adjudication, or do you simply try to challenge it when it's being enforced? You have to consider whether you want to incur the legal cost associated with defending the adjudication if it's been referred to by an insolvent company. Particularly where you have a cross-claim against that insolvent company. Now, this issue was very recently looked at by the UK Supreme Court, and they overturned the decision of the Court of Appeal, which made it really interesting. This was a case of Bresco Electricity and Michael Lonsdale. In this case, the insolvent party, Bresco, had referred a dispute to adjudication to recover debt owed to it. But rather than participate in the adjudication, the other party, Lonsdale, sought a court injunction to restrain the adjudication for some of the reasons I've mentioned previously, but also mainly because it had a cross-claim against Bresco. The first instance decision, the court granted an injunction to restrain the adjudication, which set a precedent that would make it impossible for insolvent companies and insolvency practitioners to use adjudication to recover sums due to the insolvent estate and use it for the benefit of their creditors. This then went on to the Court of Appeal, who agreed with the first instance judge and found that whilst an adjudicator would have jurisdiction to determine a dispute referred by an insolvent party, the insolvency set-off rules were fundamentally incompatible with adjudication. It found that it was neither just nor convenient for the adjudication to continue. And in fact, it described having such an adjudication as an exercise in futility. The Supreme Court, however, disagreed with the Court of Appeal. It held that the insolvency set-off rules do not, supplant the pre-existing contractual claims that the insolvent company has. They explained that it doesn't make those claims evaporate on insolvency and be replaced by a net balance claim due to the cross-claim. They explained that such contractual claims continue to exist and an adjudicator will have jurisdiction to decide them. So it's opened the floor for insolvency practitioners to now bring adjudication claims. And it remains to see how parties intend to deal with such situations and how the court as well will deal with such situations when it comes to enforcement. I think I might have gone over my 10 minutes, so I shall stop there. Thank you very much.
Thank you very much, Kash. Thank you very much, Kash. Let me ask you what may seem to be a foundational question. James described the process of dispute board adjudication, the dispute board system, and you've also described briefly adjudication. I think I'll be interested to know very briefly the distinction between the two, or why should I, having a construction dispute, assuming that from the beginning, at the time we're drafting the contract, what is the distinctive feature of adjudication that I will consider adjudication? Could you very, very briefly deal with that?
So I think it will depend on what jurisdiction you're in. So disputes boards and adjudications are very similar, and
Yeah,
depending on how your contract is drafted, they can provide you with a binding or non-binding decision. While adjudications is really non-binding until it's determined by arbitration or litigation. Now, one of the main differences is really about the jurisdiction you're in, because if you're in a jurisdiction like the UK, where adjudication is, a right that is granted to you by statute, you don't even need to have it in your contract. And
I
the
see.
great things about the adjudication procedure is that in the UK, it's a process that has to be done within 28 days of of it being referred to adjudication. So that's good news for someone that's hoping to receive money and is having cash flow problems, because then you're going to get your cash rather quickly, rather than having to go to court, and that can take you years, or arbitration that can take you years before you get your cash. And it's also good news for employers, because you get to know where you stand very quickly and know that your project can go on once the dispute has been resolved very quickly, and argue later if you're not too happy about it in court, but at least a decision has been made and you can then move on with your project.
Okay, fair enough. Thank you very much for that explanation. I think that clears it up. Matthew, I'm back to you. Matthew will be discussing the is it tiered or multi-tier dispute resolution clause? For the benefit of our folks, we're discussing dispute resolution in the construction industry, and we are focusing on dispute resolution. And oftentimes you see dispute resolution clauses with different modes, or what we call multi-tier, or simply tiered. I'll leave it to Matthew in the hope that it won't tear us while discussing this.
Thank you very much, Kola, and I will try and be brief. I have produced some slides actually, but I'm wondering whether, in fact, it might be better for everybody if I don't go through the slides and instead just share a few thoughts about multi-tiered dispute resolution clauses, and then perhaps if people want to see my slides, then they can drop me an email afterwards, and I'm very happy to share those. And let me try and knit a couple of thoughts together for things that we've heard today on the talk. Really something that James has talked about, and Cash and Professor Elias, which is, and in fact, as you mentioned earlier on, to do with how are we addressing dispute resolution in the contract. I think a really interesting example, for instance, of adjudication that I have seen, I was involved in an ad hoc adjudication on a project in Tanzania, where the parties, now there is no statutory right to adjudication in Tanzania, but the parties had agreed to adopt in effect what is contained in UK law relating to construction adjudication. And precisely for the reasons that Cash said, it's a mechanism for getting a relatively quick resolution on an issue that the parties had disagreed about, to try and understand how that would then impact the delivery of that particular item of work going forward. So it's a really good example. And as I think, as James pointed out, there are institutional forms of contract, notably FIDIC, that then try and create that within the framework of what's called clause 20, which is the claims clause in the FIDIC Rainbow Suite that I think a lot of people are familiar with in construction projects, the Yellow Book, the Red Book, and so on. And it's the attempt to create a mechanism for resolving these disputes. Now, Professor Elias raised, I think, a really interesting point right at the beginning, and it was his third question, which is what happens on a project where you have parties, as you will always get on a construction project, many different stakeholders and entities involved in the delivery of a construction project. How do you then bind them all into a dispute resolution process? Well, I think the short answer is we have seen it occasionally in terms of arbitration agreements, and there have been large projects. I think probably the most famous example of that recently is perhaps the Hong Kong airport, where on Hong Kong airport they tried to have a sort of a multilateral arbitration clause that brought in different entities, and so that they could all then resolve their disputes in a single forum. But that's not straightforward, and as I think as the professor pointed out, if there isn't complete joinder of all of those types of provisions, it can be very difficult then to bind everybody into an arbitration process. And even though a number of the institutional rules have tried to do that in terms of enabling tribunals or the ICC to joinder or merge different disputes together, it's not straightforward. So this is, I think, one of these instances where, particularly if you are a project sponsor, it gives you the opportunity in a tiered dispute resolution process to try and have those disputes resolved really before they get to those formal disputes. So for those of you unfamiliar with tiered dispute resolution clauses, well, what are they? The obvious answer is it's if you imagine like a wedding cake with different levels on it. The intention of a tiered dispute resolution clause is that you go through each level before you go on to the next level, in order to hopefully to try and resolve the dispute at each of those different stages. In construction contracts, and particularly if we look at FIDIC being one of the most commonly known, the obvious first tier is actually the contractual process, where the engineer, and there's usually an engineer, he will make a decision about a party's particular entitlement using the mechanisms that are there in the contract. And even if you're not under the FIDIC form, you'll find that many forms of construction projects will have a third party, an engineer, a contract administrator, an architect, who will be there to make a decision about a party's particular entitlement under a construction contract. So that's always the first tier, if you like. What then happens? Let's say you are dissatisfied with the decision that the contract administrator has made. Where do you go after that? And this is where I think it's up to project sponsors to try to develop different methods and different tiers for resolving those disputes. So for instance, it's very common for there then to be a senior representative stage. That usually means that you try and get somebody who is a key decision maker within each of the relevant entities, the contractor and the employer, most simply, but who isn't involved in the day-to-day running of the project. I think we've all experienced in construction disputes that somebody who is very heavily emotionally involved in a project sometimes can't necessarily take that objective view as to their particular party's rights and entitlements under the contract. So the idea is then you escalate the dispute to somebody at a senior management level who isn't involved in the day-to-day, who can then try and a little bit more objectively come to a resolution of the parties' differences. It is, if you like, a form of structured negotiation. If that tier is unsuccessful, where does the dispute go then? Well, it can go, certainly in my experience, to one of two stages. Perhaps it could go to what we sometimes call expert determination. And again, this is very similar to the DAB that you might see in a FIDIC form of contract, or indeed in an ad hoc bespoke form of contract. You might have a standing or an ad hoc dispute adjudication board or dispute resolution board who are there to try and help resolve it. And if you don't use a DAB or DRB, you might use an expert, somebody particularly who is a subject matter expert. Let's say you're dealing with, for instance, a civil engineering project, where you might want a an earthworks engineer or a geotechnical engineer to be able to get papers from the parties, look at those in confidence, and then come back to the parties and say, well, I have looked at the issues on this particular project and I have, this is my decision. It'll tend to be a non-binding decision, but it's intended to be another gateway through which a dispute passes so as to then allow the parties to sort of resume responsibility for trying to resolve the dispute. The next stage could be mediation. I've always found that there's an inherent conflict between, on the one hand, having mediation as one of your tiers in a dispute resolution clause, and mediation, if you like, at a theoretical level, because of course mediation is supposed to be a consensual process. Parties only go to mediation if they both want to go to mediation, if they both feel that their dispute can be resolved with the assistance of a mediator. The conflict, if you like, is between that and then having a clause which mandates that the parties must go to mediation. I think, as you can see there, there's an inherent sort of tension between those two particular positions. And I think this is perhaps, if I'm going to throw in a little bit of law, this is one of those areas, I think, where there is a conflict between what the law requires and what parties might want to do. There's both a decision in English law, and I can point to a decision in French law as well, where if the parties have agreed to mediation as a step, then they must go through with it before they then proceed to a formal dispute resolution mechanism such as litigation or arbitration. If you're interested in having the details of those decisions, let me give you the case names. In English law, it's a decision of the Commercial Court, Emirates Trading Agency and Prime Mineral Exports Private Limited. It's a 2014 case, the Commercial Court in England. In France, it's actually a decision from the Cour de Cassation, which is the highest court in France, February 2003, and the court ruled that legal proceedings commenced in breach of a compulsory mediation clause rendered the claim inadmissible before the arbitral tribunal. So these are, if you like, all of the different tiers through which a claim should proceed before then eventually you get into litigation or arbitration. And the idea is that it enables parties to try and maintain management of their dispute for as long as possible. It's certainly my experience that the longer a party retains its own decision-making process and its own powers over its decision before handing it over to a third party, that tends to be better in the long run in terms of its own commercial position and its relationship with third parties that it tends to do business with. So that is why I think parties enter into these tiered dispute resolution clause. And as Professor Elias pointed out, the other obvious reason is it makes it much more, there are many more options for particularly project sponsors who want to bind parties in to a sort of a multi-party process. Well, it's a lot easier to do that through a tiered dispute resolution procedure before you then eventually end up in either litigation or arbitration. So I hope that gives you a sort of a brief run through. And as I say, I've prepared some slides, and if people would like to see them, then I'm very happy to share those. Thank you, Kola.
Thank you very much, Matthew. Definitely we want to see and read the slides, because again, I think you've been able to pack about a decade's worth of experience within 10 minutes. So we are quite grateful for your thoughts. Definitely, I'll speak with the organizers to see if they could circulate the slides to everyone. I'm particularly interested in your thoughts on the conflicts between parties voluntarily agreeing that we want to mediate this dispute, as opposed to a contractual obligation for them to go. And they could very well get there and say that we don't want to mediate. But I think today is perhaps not the day to debate that. So I'll move on. For the benefit of participants, if you have any question, if you have any comments that you want us to ask or to put across to the panelists, can you please put them into the chat box? Because I intend to finish this session by 2:30 on the dot, as indicated. So, so I come to Abdul Jinodu. Abdul will be speaking for 10 minutes on termination of contract. Abdul?
Thank you, Kola. Can you hear me?
Very well.
I'm good. I'm glad. Thank you very much. Thank you, Kola. Thank you for the kind invitation. I'm happy to be here this morning. I've got to pack a lot in 10 minutes. Now, termination, as you can imagine, is a huge subject. So I'll just try and deal with some of the highlights as I see them. I think the key to start with is something that other panelists have mentioned this morning, which is the contract, the contract, the contract. Everything comes back to the contract. Most construction contracts, certainly the standard forms that one thinks of, FIDIC, NEC, the JCT here in the UK and Australia and South Africa to a more limited extent. Even the old RIBA forms, which I know that are still in circulation and still in use in Nigeria and other African jurisdictions, they all contain provisions that deal with termination. And those those provisions set out a clear contractual mechanism by which the parties can bring the employment of the contractor under the contract to an end. Now that's an important point there. When you terminate a construction contract, the same way as you terminate any contract, this sort of contract 101, you're not bringing to an end the entire contract. What you're doing is terminating the employment of the contractor under that contract. That's important because once you bear in mind that termination does not halt all obligations under the contract. So for instance, if there are provisions in the contract dealing with the insurance of the works or the assignment of risk of damage in the works, those may survive termination. So one has to be cognizant of that fact that simply by bringing an end to, by terminating the contract, you're not necessarily bringing to an end the relationship that you have. Another provision in the contract that survives termination is dispute resolution. Seems obvious, but that it does. Dispute resolution clauses survive termination of the contract, and the obligations they impose on the parties continue post the termination of the contract. Another issue, and in terms of what's topical, a topical issue at the moment is the extent to which liquidated damages provisions survive the termination of the contract, and whether or not in a circumstance where an employer terminates the employment of the contractor and then re-engages a new contractor to finish the works, at what stage does an entitlement to claim LADs as opposed to general damages? At what stage does that obligation cease, or that entitlement cease? And there are conflicting authorities on this point. Court of Appeals, recent Court of Appeal decision on the point, which runs through the various authorities. I think to summarize it, and I haven't got time to go into detail on all of it here, I think summarizes it to give a typical lawyer's answer. The answer, it depends. It depends on the facts as to when the LAD obligation ceases in case of termination. Now, another important distinction to draw when it comes to termination is termination under the terms of the contract and termination at common law. In common law jurisdictions, there is the general right to terminate an employment under a contract for repudiatory breach. The extent to which that right continues to exist in the face of the contractual provisions, again, depends on the contract. And I'm going to be referring or making reference to the FIDIC form of contract, both the 99 edition and the later 2017 versions of FIDIC, because they contain similar provisions. And FIDIC tends to be sort of, in international contract, it's sort of the benchmark. Yes, you get projects that are done on different forms in different jurisdictions, but generally internationally, FIDIC is viewed as being the benchmark, and I'll use that for that purpose in this talk. Now, FIDIC expressly reserves the right of I mean, the way it's put in FIDIC forms that the right of the employer to terminate shall not be the provision in FIDIC entitling the employer to terminate does not prejudice any other rights that the employer may have. So FIDIC expressly preserves the common law rights to terminate. So those two rights sit side by side, and that gives the employer in those circumstances the election as whether he terminates under the contract or terminates a common law. Now, different considerations will apply as to which or both an employer would choose to exercise. In relation to termination under the contract, as I said, the contract will lay out a detailed contractual mechanism pursuant to which either party, whether the contractor or the employer, can exercise the right to terminate. And that constitutes at least 2 or 3 steps. The first step is the existence of the circumstances which would entitle either party to terminate. Absent those circumstances, the defined circumstances, there's no entitlement under the contract to terminate. Under FIDIC, so far as the employer is concerned, under clause 15, the circumstances are things like failure to provide a performance security, abandoning the works, failing to exercise, to execute the works pursuant to provisions of the contract, in relation to commencement, delay and suspension, giving of bribes, that sort of thing. So that creates a circumstance in which the employer has the right to terminate. To then terminate, he then has to operate those provisions and comply with, crucially, the notice provisions in those provisions. So contracts which contain contractual termination provisions will set out clearly what the steps that whichever party is the contractor or the employer has to take to ensure that he exercises that right properly. Now, those can be very detailed. For instance, it could require a series of notices to be given. So in forms such as the JCT, there's a 2-stage process where you give effectively a warning notice that you are in breach for this reason, and unless you cure that breach within a certain amount of time, I will terminate. If the contractor or the employer doesn't receive that notice, doesn't cure the breach, then the entitlement then arises as to whether or not you can terminate. And to terminate in those circumstances, they have to give a separate notice saying, I hereby terminate. Those notices are, it's crucial that if one is going down that route and proposing to you and to utilize those contractual mechanisms, then you should do everything you can to make sure that you comply with the provisions of the contract as to how you give the notice, the form of the notice. So if the notice requires it to be given in writing, handed in person to the contractor's representative on site, then you have to do that. If you don't do that, then you run the risk of your termination not being valid. And that could put you in repudiatory breach. So it is important to stress that if there are contractual provisions relating to termination, that you follow as closely as possible those terms that are set out in the contract, and you do not deviate from those terms. So if it says it has to be a notice in writing given in person, it does you no good to send an email to an email address. That would not be valid termination. Now, there are different authorities in England, more recent authorities in England, regarding the strictness with which courts review and interpret those provisions. But in my view, I think you are risky, the risk is just not worth it. It's not worth taking the risk and failing to comply and ending up being in repudiatory breach. Under FIDIC, I've touched on the circumstances that entitle the employer to terminate under clause 15. The entitlement of the contractor to terminate is dealt with in clause 16, and circumstances giving rise to entitlement to terminate are things such as a failure to make payment. Now, that's slightly complicated because preceding the right to terminate, there is a right to suspend. If you suspend for a period of time and the payment is still not forthcoming, then you have an entitlement to terminate. The again, if the employer becomes bankrupt or the employer substantially fails to perform his obligations under the contract, those are the sorts of things that would entitle a contractor to terminate under FIDIC. And you find similar provisions in the other standard forms of contract. An interesting sort of third, as well, third type of termination is a termination for convenience. So FIDIC provides for the termination without the circumstances that are set out in clause 15 having existing. Essentially, it gives the employer the right to terminate for convenience, clause 15.5. So the employer in those circumstances doesn't need an excuse to terminate. He can simply terminate if it suits his commercial purposes to terminate. And this is potentially relevant to the circumstances in which we find ourselves in now with COVID. There are many projects that were designed, that were procured, engineered, designed on the basis of certain assumptions about the general economic outlook globally. Now that things have changed so dramatically, lots of employers are looking for ways to get out of contracts they've signed with contractors. And
Force majeure.
Well, exactly what force majeure is. It is an option, but force majeure comes with difficulties, a particularly definition of what constitutes force majeure. Under FIDIC, one way of getting around that is the termination for convenience provision, which allows the contractor to simply, the employer to simply pull the plug. Now, it's not cost-free, because that then entitles the contractor to certain remedies and certain payments if the contract is terminated. And that's something that's worth considering if the employer is considering pushing that button. But that is, as I said, that's particularly relevant to where we find ourselves in now with COVID and with the circumstances that we now find ourselves in. Now, in terms of, sorry, Paula, I'm out of time?
5 minutes over time.
Okay, I'll apologize. I'll stop that. I've covered most things I want to cover, but I think that should cover most of it. Thank you.
Thank you very much, Abdul. Much grateful. Most of what you said is not very good news to me, because I thought I would just stroll to my building site and just kick out the contractor and say, "Hey, you get out." Wow. Okay. So, but just one point. You made mention of a case in where they said, if termination is required to be in writing, an email would not suffice. Yeah. Even if you've been exchanging correspondence with the contractor via email, they've been responding, probably the contract document itself, it was exchanged via email. What do you say to that?
Well, you can try and mount an argument about waiver, but it's risky, and I wouldn't try it, because I said the consequences of you being wrong are that you are in repudiatory breach. And it seems to be that it's such a small, it costs you nothing to comply with the provisions, and it's not worth the risk for you not to comply. And given the downsides, it's not something that I would recommend that anybody do.
Absolutely. Thank you very much, Abdul. Much grateful learning from you. So we started with a professor of law, and we're also going to end up with another professor of law. Jide, Prof. Jide, you're welcome. Take the floor. Jide will be giving us an overview of trends in the dispute resolution in the construction industry. Jide, over to you.
Thank you. I'm grateful to the speakers who set the stage, and I think it's good the way it goes, the way it went, because I wanted to speak to the future. Whether we're talking about error in contract, claims, maladministration of contracts, etc. I think the problem with the construction industry, in terms of where we are concerned, dispute resolution professionals, is speed of resolution. I think their conflicts will always be there, and I wouldn't focus on it. But I think the core thing is, what is the problem? The problem is speed of resolution. So what should we do as helpers of the industry I think what we should do is helping them to more and more immediately address their conflicts. It doesn't mean we will not have any dispute resolution work to work on this. The conflict resolution industry for me is the biggest. It's huge. There's always work to do. And for the construction industry that concerns us, I think if we can put on their fingertips the skills we have to quickly resolve conflict, we would have done them a huge favor and benefit, which is important, not just for the industry, for the society. And so that's what I write about. That's what I talk about. Kola was asking about my book. That is, I'm trying to show you. That's the book. And I'm trying to say we should begin to look at a more effective way of looking at these disputes and conflict that would always be there. So my core point is that we should take the responsibility for conflict resolution in the construction industry from ourselves and put the responsibility on the parties. Now, we will still be arbitrators, mediators, adjudicators, early neutral evaluators, mini-trial neutrals, and all of that. But I think that we need to demystify our conflict resolution because the more we are able to empower them to quickly deal with the dispute on ground, the more we would have done two things: make the industry more robust and go back to the reason why we had arbitration in the first place, which was immediate dispute resolution at the site on the venue. Having said that, I try to, well, obviously you could see that my bias would be for amicable dispute resolution, because most of the other dispute mechanisms that we apply are actually antagonistic. And I think that while I like to be an arbitrator, like to be a lawyer, I think going forward, we should be thinking more and more of amicable dispute resolution. And at page 85 of my book, I try to give a picture of what I think that means. Now, what am I saying? One, in the contract they write, we should move more and more from arbitration clauses, stricto sensu, to dispute resolution clauses. And I think James and Matthew spoke to that. Be thinking, writing in the dispute resolution clauses, something that says if there's a conflict, they if it's a big, should do mini-trial, what I prefer to call mediated conflict negotiation. And then if that fails, then a mediator. And it is when everything has failed, which is most unlikely, that you bring in an arbitrator. I think before the arbitrator comes in the 1, 2, 3, 4, 5 days, they are using all those other negotiation processes. The conflict would have been resolved almost certainly. I mean, the statistics are very clear that when they use amicable resolution, they're able to kind of find a quicker resolution. And so the second thing is that we ourselves need to master, in addition to being expert arbitrators and all that, we need to master the core of mediation. What makes it work? Now, when I talk about mediation, I'm not just talking about where a third party intervenes. I'm also talking about where the parties themselves do what I call self-mediation, which is really negotiation. It's applying the skills they see us do. I mean, we're always with them. When we do mediations from time to time, the parties are watching us. And then when next time, or the third time, or the fourth time, fifth time, when they have a conflict, they're able to apply the skills I'm sharing with them. And so at page 5, I kind of give a picture of that, gathering through confidentiality, through empathic listening, through other things like that. You get the parties to kind of learn to feel at home with themselves, so that they don't rush to an antagonistic method every time there's a conflict. And of course, once you have that first foundation of foundations, ability to speak effectively to one another, not seeing conflict as something that is bad, but as just telling them that this relationship we have, this contract we have, which is a relationship like any other relationship, has unmet needs. That's the reason why they have conflict. There's an unmet need on claims, on carrying out the contract and all that. And of course, when we do that, we're able to hear the story in a way that is really empathic, and then we rehear the story. When I say hearing the story, of course, I don't mean all the parties are talking about. When I'm listening to a party, I listen as if he has all the story, and as if what he's saying, my life depends on it. And what happens is that she or he opens up and is able to quickly let us know what the problem is, and do the same thing with the third party. That's what I mean by rehearing the story. And of course, we'll do that using caucusing, using introspection, using dialectics. We're able to reach understanding, and then the parties are able to move to effective resolution. Now, as easy as that. Yes, I think it's like that. I think that what parties are looking to us for is not, I'm sorry to say, but they don't, we are really, in a way, nuisance value. I mean, they would prefer if we are not. So we need to begin to accept value. This costs them money. Sometimes it slows down everything, but it is true that you could resolve, you could do arbitration quickly and go on, but well, that sometimes that Nigeria has that's hanging somewhere in the English courts. Award was given, but nothing's happening. No one. So that's the paradigm I'm coming from. That we should begin to see ourselves as people helping the industry to be more friendly, and so that if we take the approach I think I'm proposing, more and more, they would develop a new system. There are several models that we talked about that we've been trying in the past. I think more and more, if we begin to push them towards doing it themselves, telling them their responsibility, and they see us showing them when we're mediating and negotiating with them and doing military, you begin to move towards a more amicable system. And then before you know it becomes not only fingertips, but also mainstream in the industry. That's what I want to contribute. Thank you.
Thank you very much, Prof. I think we must begin to draw the threads together now. James tied up very well with the dispute boards, and I was quite refreshed hearing from him. Cash also advocated for the adjudication. Matthew took us through the multi-tier dispute resolution clause in the construction industry. Abdul gave me the bad news, which I didn't want to hear, that kicking out a contractor is not as easy as that. And Prof told me that there are different ways of handling conflicts. So let me just put everything together this way. Construction projects are typically hugely expensive projects, and conflicts are typically bad news, because one way or the other, you can be staring a delay or staring at some damages in the face. But it's not all bad. The way that it's handled will depend on whether you are going to have a good project or whether everything might end up being or end up in frustration. I think that one of the starting points is actually due diligence about the kind of contractor that you have. In many projects, I've said that subcontractors are hired merely on reputation, they have a big name. And then in the middle of the contract, you now discover that the contractor might not be suited for that kind of work. And that comes with its own set of conflicts. Today we've heard that it's not all about dispute resolution. James made the point that we should also strive for dispute prevention, which is a key word to me. We've also heard about, dispute prevention, dispute avoidance, dispute management. All these are phrases, all these are concepts that teaches us that we must learn to handle disputes in a more appropriate manner in order to achieve the best result. All these modes, adjudication, dispute board, mediation, expert determination, negotiation by senior officials of the company, all these are mitigation techniques, which I think we'll all go back and scale up on. So once again, I want to thank you all for your time. I must not forget Professor Elias, who actually got the ball rolling. Professor Elias shared selflessly of his experience in dealing with construction contracts in Nigeria. And he again made a very vital point that particularly for a public contract, if you do not go through the hoops of the Public Procurement Act, everything might eventually end up in a journey of futility. So on this note, I want to thank you all for a very good presentation. I've learned quite a good deal today. I'm looking at the chat and I see that someone said that, can we make the videos available? I think at this stage, I will hand it back to Larry and Tosin without question. How early can we get the video?
Okay. Hello, can you hear me?
Loud and clear.
Okay, thank you so much, Kola. You did a very fantastic job. Thank you so much. Okay, as for the videos, we will make the videos available on our website. We are going to be putting them in writable and Titan format, such that anyone who wants to access them will be able to access them as soon as possible. So I want to say a very big thank you to Professor Elias. Thank you so much for chairing today's event, and thank you to our audience as well. Thank you to our audience. Thank you for participating in today's webinar, and to all our speakers, we really can't thank you enough. Like, we can't appreciate you enough for taking out the time to prepare and also to present your papers. I must say that all the presentations were very rich and were well-researched content, and we are really grateful for them. Thank you so much for making out the time. And we'll also like to inform you that our next webinar series on capital markets, the topic is state of the equity markets, where's the pipeline, will be holding on Wednesday, 20th of January, and at 1 p.m. Our distance learning power program is also, registration is also on. So you can also contact me on my email, o.chilanke@esqlaw.com. I also want to say a very big thank you to our sponsors, to G. Elias and Advocate Law. Thank you so much for sponsoring this event. We really, really appreciate it. Yes, the email once again is o.chilanke@esq-law.com. So thank you all so much. Thank you, our panelists. Thank you.
Sorry, Tosin.
Yes.
I can see that someone posted a question that I want Professor, where is he? Oh, he's gone. I want Professor Jide to quickly resolve within some few seconds. The question is, thank you for your presentation. Is the method you recommended being applied now? If they are, what models of training are being employed? are there institutions responsible for training parties for this purpose? I see that Matthew said interesting questions. The CIAB and the Royal Institute for CS provides training. But Prof. Jide, 10 seconds.
Yes, well, in Nigeria, we have ICMC, you have corporate mediators, you have this sort of construction industry arbitrators. We can begin with the last and then go backward. I could offer more information if Emmanuel wants, but yeah, there are.
Thank you very much. So,
and the processes are being applied. And the processes are being applied. Thank you.
Excellent.
In Nigeria.
Tosin, are you offering us lunch as we break out now?
Virtual lunch. Okay, thank you all so much. Enjoy the rest of your day.
Thank you very much.
Bye.
Thanks, everybody. Bye-bye now.
Cheers. Thank you. Bye.
Bye.